So, a warm welcome to everyone to this webinar, and very sorry for these initial technical setup issues. I think Teams is, at least for us, for this webinar setting, a new platform. So yeah, there's always some points to address at the beginning. So my name is Teresa Morda. I'm a researcher at the Institute for Comparative Federalism at Zurich Research, and I'm going to moderate our time together. And while people keep connecting, I'm just going to say some introductory words and some organizational details about the following 90 minutes. So at the center of this webinar today stands a recently published book, which is titled Accommodating Diversity in Multilevel Constitutional Orders, Legal Mechanisms of Divergence and Convergence. The volume was edited by Maja Sahadžić, Marjan, Jaka, Kukavica, Jakob, Gašperin, and Julian Scholtes. And I'm really sorry if I mispronounced some of the names. And so I'm excited that we have actually all 5 editors of the volume here with us this afternoon, together also with my colleague Karl Kössler, who will act as a discussant to this webinar. So hello to everyone, and thanks a lot for being here with us today. Just some organizational details before I'm going to introduce our speakers more duly. In the next 90 minutes, we're going to have a mixture of short presentations and a discussion part, but there's also going to be the possibility to ask questions and comments, which we're going to address then afterwards in the Q&A session. And for this, please feel free to put your comments into the Q&A session, which you can also find in this top bar. Among the different options, there's a small Q&A button, and if you click on there, you can put your questions there. Feel free to do so throughout the webinar, and then we will address them afterwards in the Q&A session. And on a technical note, I would also ask everyone to keep their microphones on mute when they're not speaking, just to minimize interferences. And before giving over to the speakers, I would also thank my colleagues at Zurich Research who allowed this webinar to happen. Above all, Francisco Javier Romero Caro, who just had to leave due to clash in meetings, but he put everything together on both the conceptual and the organizational side. So thanks a lot to him, and also to my colleague Martina Gianola and the colleagues from the meeting management for their technical assistance to this webinar. And now in the first part, we're going to hear about a round of inputs and introductions to the book by the editors. If I understood it correctly, just some of them are going to speak, but I will just briefly introduce all of them and then hand over. So Maja Sahadžić is an assistant professor of constitutional law at Utrecht University and a visiting professor at the University of Antwerp in Belgium. Her research involves mainly around multilevel governance, dynamic legitimacy and stability, asymmetries, constitutional values and principles, fundamental rights, and constitutionalism under extreme measures, among other fields. Then Marjan is a PhD candidate and research and teaching assistant at the Faculty of Law of the University of Ljubljana in Slovenia. And he's also the secretary of the Constitutional Law Association of Slovenia. His main research focuses on federalism, European constitutional law, differentiation in European Union law, and fundamental rights protection in the European Union. Then we have Jakob Kukavica, who is a PhD researcher at the European University Institute in Italy and a junior lecturer at the Faculty of Law at the University of Ljubljana in Slovenia. And his research focuses on the fields of constitutional law, European Union law, human rights law, and comparative law. And then Jakob Gašperin is a postdoc researcher at the graduate program Dynamic Integration in European Law at the Humboldt University of Berlin. And there he also recently completed his PhD on national constitutional identities in the European Union. In his research, he engages with topics of comparative constitutional law, legal theory, European common security and defense policy, fundamental rights, and public international law. And Julian Scholtes is a lecturer in public law at the School of Law of the University of Glasgow in Scotland, UK, and his research interests lie in the areas of comparative constitutional law, European Union constitutional law, and constitutional theory. So a lot of introductions, and I think there's certainly going to be a possibility to sort of connect to the individual speakers also afterwards. And now I would pass the floor to you, Maja, for the introductory part.
Thank you so much. I think Jakob and I thank you so much for inviting us, actually. That is the first thing that I actually have to say, right? And thank you for inviting us to Europe, which is always a pleasure, at least for me. And I hope for my colleagues in the future, they will have the opportunity actually to come and visit Europe and meet all of the fantastic people that I've met along the way. And now also you, Theresia. Jakob and I Jakob will deal with content more closely, and I will just give you the introduction on how we actually created the idea and how we developed the book and what are the main ideas about the book, essentially. Actually, we started with a conference in Ljubljana in 2021, and that was during the pandemic, and therefore it had to be in a hybrid format. But we managed to tackle some of the issues that we wanted to tackle in that particular conference. And those issues were the questions around accommodation of diversity in multi-level constitutional orders. That would include, of course, convergence and divergence. And it was only logical after the conference to have an edited volume about the conference papers that were submitted. Of course, it needed a little bit of structuring. It needed a little bit of better organizing papers, and some of the authors could not contribute. So we needed also to invite authors to, as I said, to streamline the edited volume. But the main research question remained the same, and that is, how does the law accommodate diversity in multi-level constitutional orders? And I think the answer to this question is actually the core message of this book, and that is that the book actually examines the legal mechanisms that are adopted in multi-level constitutional orders to accommodate this tension between unity and diversity. The last book that tackled this particular issue was published more than 20 years ago. So we had a pretty big gap sort of to fill. And so we needed to update. That was a book on convergence and divergence in European public law, and it was edited by Beaumont, Lyons, and Walker. But we needed to update the volume quite significantly because, as I said, 2 decades ago was quite a bit of time. And we also needed to put focus more on, let's say, comparative perspective. And that's what we intended and tried to do in the book. And we tried to do more beyond the EU law. For the book, essentially, we wanted to take into consideration the systems, or for the conference and then for the book, we wanted to consider systems that we would call multi-level constitutional systems, but are actually systems. These are actually systems that are legal orders composed of multiple layers of legality, and they could be at the same time separated, but also interconnected. We also realized that they could be either single system, single entity, like a federal state, but it could have been also that they are composed of several different entities, such as the Council of Europe, such as the European Union, and so on. So essentially, they could have been either international, supranational, but also subnational or national at the national level. So it was this kind of determined how wide could we go in terms of our methodological approach or the selection of the papers for this edited volume, or even the scope of interest, sort of to say. But then also to look more closely into these systems, we needed to emphasize some of the basic features. And of course, there's diversity, which by course, by the very design, by the very essence of these systems, diversity comes forward. It is very specific to these systems because there are different, very specific interests in the component parts that need to be accommodated. And diversity as such stems not only from the social reality that feeds the legal reality, but it could be also vice versa, as shown also in the papers, and that causes transformations within those systems. So it's the tension between unity and diversity that we wanted to look more closely into, or how to hold the system together. And the second feature I think that was important that we wanted to look into was complexity, which is quite, let's say, inherent to these systems because of the multiplicity of the relationships that actually happen within those systems. And complexity does not affect only the principles of equality or transparency, but it also challenges accountability, effectiveness, fairness in these systems. So it was important to look into it for the fact that it, to some extent, or to some greater extent, depending on the type of the system or the type of the study that has been done in the book, it implies the lack of coordination. And in the end, I think this tension between unity and diversity was transformed into looking into the balance between effectiveness, so how effective these systems are, and into what is a compromise or the justified compromise, as we called it, so that system can actually hold together. In trying to know more about these systems, we also understood that we needed to address some of the global problems, which were, for example, the pandemic. Of course, the conference was during the pandemic, but also, of course, climate change, migration, and so on. But there were also some of the very local, regional governance problems that were also affected, multi-level governance in these systems, such as, for example, the intellectual property law or the protection of fundamental rights and so on, and vice versa. It could have been gone two ways. But all in all, it was always about coordination. It was always a question whether there was the action required to maintain a certain degree of coordination between either different levels, horizontally or vertically. I think that by looking into all of this, we've noticed that we were looking mostly into the institutional setup. We were looking into the division of competences, and we were looking, all in all, we were looking into theoretical foundations for the accommodation of diversity, but we were also looking into the mechanisms convergence, but also mechanisms of divergence. So that is what we saw throughout. That was the streamline or one basic line that we draw out of the papers that were submitted to the edited volume. And yeah, from the theoretical approaches, we've noticed that there were some approaches that are quite usual in accommodating diversity, and that would be, I don't know, differentiation, asymmetry, and so on, interlegality. And then we also noticed that some of the mechanisms of the accommodation that refer to convergence and divergence were well known, and some are, of course, less known, but all in all, they refer to, for example, proportionality, consensus analysis, margin of appreciation, distribution of competences, citizens' initiatives, and so on. So as I said, in the end, I think the project actually showed that we do have theoretical aspect, but we also have mechanisms of convergence and divergence, that is a very practical aspect of how to deal with the accommodation of differences. So that is basically what the book is about. In my humble opinion, I think that the manuscript is very well-rounded in terms of this theoretical approach in how it addresses this dialectics in multi-level systems. It also focuses on some of the relevant areas in constitutional law, especially when it comes to institutional aspects and the protection of fundamental rights, fundamental human rights, if you want to. And it also provides a little bit of different take on the unity-diversity dichotomy, because it really takes into consideration not only the national level, which is quite usual to take into consideration, but also some supranational and international level. And also, I think it helps us better understand how these mechanisms actually impact the multi-level legal orders, and what is their impact on the stability of those systems. And so I think by offering this analysis, we can actually have more insight on the systems, on the functioning of the systems in a more stable way. But I leave it to Jakob to tell you more about the content and to actually make the actual conclusions about the edited volume.
Thanks a lot, Maja. And good afternoon to all of you. And also thank you for the kind introduction that we had at the beginning. So let's just start with the very book that we have in front of us, because I'm not sure that all of you have the book in front of you. So the book, as you know, is titled Accommodating Diversity in Multilevel Constitutional Orders, with the subtitle Legal Mechanisms of Divergence and Convergence. And if we go to the following slide, we will see, and I will now present the book, which is also structured in 3 parts. That's also the way how I will just present the content of it. So the first part of the book is basically the theoretical approaches. Those are the chapters from 1 to 4, and I will skip the introductory chapter 1. And then, of course, we have the section 2, which kind of addresses the areas of law in relation to the convergence and divergence and different mechanisms. So basically, you have different mechanisms, in particular in constitutional law and in human rights law. Those are the chapters from 5 to 9. And in the last section, we basically have the subjects. We have basically different institutions, and then therefore institutional mechanisms of divergence and convergence. And those are the chapters from 10 to 13. And the last chapter is the introduction, which the same as the conclusion, excuse me, which I will, the same as the introduction, not include into this presentation. So if we go now to the next slide, which is basically the first part of the book, the section 1, the theoretical approaches, we have chapter 1, chapter 2, 3, and 4. After the introduction, we have chapter from Gabriel Enquinas, and I'm sorry if I'm not saying this correctly, the idea of interlegal balancing in multi-level settings. Then we have chapter 3, non-hierarchical coordination of multi-level asymmetries for dynamic stability, from Maja Sahadžić. And chapter 4, constitutional diversity and differentiation in the EU. What role for national constitutional demands under EU law, from Marjan. So if we go now to the next slide, we will see some of the major takeaways from this first part, from the theoretical approaches. So to be fair, the book is addressing quite strongly the issues of the European Union, but is not limited to the European Union. But now if I just focus for a second to the European Union, we can see that basically the institutional setting of the European Union is in itself basically already kind of diverging and converging by its very design. And then we have the different examples, such as the primacy and direct effect on the one hand, but also then respect for national identities and also national sovereignty, although that's not the language that the treaties are using. And basically, those multi-level systems within the European Union, but also in other systems, they have some specificities, some peculiarities, and these are that basically all those systems are extremely complex and extremely diverse, and they have somehow contradicting goals, that they want to find the balance between the unity and plurality. So from this first theoretical part, we can kind of make three major theoretical conceptions. One of them is so-called interlegality. That is basically the new concept which tries to transplant the concept of balancing from the classical legal dogmatics, when we are balancing between two rights or two principles, into the balancing between different levels, different systems, different constitutional layers, so to speak. So basically to use proportionality and balancing in a broader sense among different systems. Then we have the coordination and asymmetry, which basically comes from the fact that that a lot of problems are coming from the fact that there is a lack of cohesion in those complex systems, which is the consequence of the lack of adaptiveness among those different parts, lack of trust, and lack of coordination. So all those elements are kind of resulting to a fact that we have a lack of cohesion, which kind of creates a lot of problems. And in order to address that, we should increase or enhance coordination and also accept this asymmetry among those different levels. And thirdly, we have the concept of differentiation, which aims to reconcile, on the one hand, the primacy of EU law and the commitments to an ever closer union, and on the other side, that the member states are aiming to remain some of the sovereignty, that there are some exceptions to the primacy, and also there's an enormous plurality and diversity among the member states. So this concept of differentiation kind of normatively incorporates those diversities as part of the system as such. So going now from the first part of the book to the second part of the book, and that is also the next slide, which is then the section 2. And in the section 2, we have basically different mechanisms in the different areas of law, in particular constitutional law and human rights law. In chapter 5, by Peter Erdkerz, we have the chapter Between Unity and Diversity, EU data protection legislation as a catalyst for a constitutional trilogue. We have chapter 6, written by myself, Forgetting Identity Claims. Chapter 7, by Thomas Verhelen, Convergence and Divergence in EU External Action, the very slowly emergent doctrine of shared competences. Chapter 8, a convergence movement between the European Union's economic constitution and national economic constitutions. Lessons from the Portuguese case, from Pedro Coutinho. And finally, in the second part of the book, chapter 9, towards a general typology of consensus analysis, from entrenching divergence to constituting convergence, by Jaka, Kukavica. So if we go now to the next slide, we will see some of the major takeaways from those areas of law, so constitutional and human rights law, as I said. The first one is so-called institutional trilogue, which means that there is not only what is usually claimed, the dialogue between the apex national courts and the Court of Justice of the European Union in the context of the European Union, but then there's also the European legislation, which plays a very important role in creating this kind of triangle. And the chapter that I mentioned is basically built around the EU data protection as an example to show this those three elements connecting, this interplay among those three institutions. Then we have the very classical and well-known issue of national constitutional identity, which of course plays a role how to find this balance. But then the chapter that I'm mentioning is also kind of asking whether in certain areas, in particular in the area of fundamental rights protection, maybe identity claims are not as productive as one might think of. Then we have the issue of the external relations, where basically the European Union doesn't really have the power to solely act or to have the exclusive competences in that field. Nevertheless, it is shown that basically the Court of Justice of the European Union developed the doctrine of shared competences, and in that way kind of enabled its role, and enabled for itself a different balance between the member states and the European Union. There's another mechanism which kind of shows how basically national constitutions are impacting on the constitution or the economic constitution of the European Union, and also the other way around. So basically we have this reciprocal two-way relationship where the European Union is impacting concretely on national constitutions and the other way around. And then finally, we have in the second part of the book the mechanism of the consensus analysis, where it is shown that basically a particular mechanism can play a different roles, either to be a tool for convergence or divergence. So in that sense, we can see that basically according or due to the different aims that perhaps different courts are following, we can use a certain mechanism, in that particular case consensus analysis, to either find more convergence and divergence in the different systems. Okay, so now going to the third and final part of the book, we have the so-called section 3, which is basically about the subjects. It's about the institutional mechanisms. In chapter 10, we have the convergence, divergence, and strategic interactions of international courts. Lessons from the protection of business premises for legal persons in Europe from Aldrey and Plan. In chapter 11, we have converging on structures, the influence of court structure on convergence and divergence among judges from Alexander Lazovic. In chapter 12, multilevel governance in the EU through deliberative democracy, zooming into the mechanisms of the European Citizens Initiative from Agata Magdalena Poznanska. And finally, chapter 13, EU law's contribution in streamlining member states' enforcement structures, a promising mechanism for convergence from Peter von Klehenbeugel. So if we go now to my last slide, and I will mention now a few takeaways from the third part of the book of the institutional mechanisms. One of the important elements is basically how the courts are gaining or claiming its legitimacy, and in that sense they're kind of referring to one another. So we have basically convergence as a legitimacy enhancing mechanism by the courts, which is then used strategically when the courts want to kind of increase their legitimacy. They refer then to the older practice. Another element is intra-institutional dynamics. We have a chapter which shows how basically some structural factors within a specific institution, in that particular case it was the Court of Justice of the European Union and the judges, how these institutional structures are basically influencing the judges to achieve a desired balance or cohesion, despite the fact that they're coming from very different places and being very different. Then we have a mechanism of deliberative democracy, according to the example of the mechanism of European Citizens Initiative, ECI, which claims and argues that kind of supranational democracy, despite its own problems in design and maybe question effectiveness can basically achieve a certain balance between the unity and diversity within the EU. And finally, it's interesting how basically the European Union doesn't have any power within the ambit of the application of EU law or concerning the enforcement of the EU law. However, the EU institutions basically achieved that also the national enforcement institutions kind of aligned among themselves due to the prescribed requirements that the EU law then kind of slowly build up over the time. In that way, the European Union then achieved that even in the areas where basically there's almost no power of the European Union, we have certain converging forces influencing the national enforcement institutions. So if we go to the one last slide I forgot, we also have a short screenshot from the book where we can see that we have some mechanisms coming from the theoretical approaches, how to accommodate diversity, and then we also have mechanisms of accommodation of diversity via degrees of convergence and divergence, and we put in the book some of those mechanisms. I think I'm at the end of my presentation, so thank you very much for your attention, and I'm very much looking forward to the further discussion with you. Thank you.
Thanks a lot, Maja and Jakob, for these comprehensive insights into how the book came about, and also for this overview over the contents of the book. And I would now right away jump to the discussion section of the webinar, where we first hear inputs by our discussant, Karl Kössler, and then afterwards there's also possibilities for everyone to put questions and comments. So I also invite you to put also them already in the meantime into the Q&A function. Now, Karl is a senior researcher and research group leader at the Institute for Comparative Federalism at Europe Research, and sitting actually right next to me in the office next door. Karl has a background in comparative public law and political science, and his main fields of expertise are comparative federalism and local government studies, as well as institutional design in divided societies, where he focuses on questions of territorial and non-territorial autonomy and power sharing arrangements. And he has published and lectured widely on these topics, both in Europe and beyond. I pass the word to you now, Karl, and I'm excited to hear about your comments.
Well, thank you so much, Theresia. So first, of course, I would like to congratulate the editors to this book. So I guess as we have a bit more than 50 minutes, and I see that we have quite a lot of participants there, I will only start with a few points and then add maybe some backup points later on during the Q&A section. So what I found interesting about the book is that it's obviously a very well-curated collection of chapters, and especially a point that you mentioned in your introduction, that actually it's a group of young academics putting this together. So it's kind of a peer-to-peer collaboration. And you rightly mentioned that also as an asset of the book, because I guess it's also different. The perspective is different. What I found quite challenging, I think, having never actually edited a book with more than one co-editor, how you can actually manage a book with 5 people being involved. So this is quite a challenge, I suppose, but you managed to do it. What I think maybe the introduction at the conclusion shows maybe a bit the difficulties of having 5 editors, because I see that 3 of you wrote the introduction and 2 of you wrote the conclusions. And I found, even if the introduction is, of course, has the traditional approach of introducing the book chapter by chapter, whereas the conclusions rather take a book section approach, and then within these book sections, there are it's more topic oriented, but still there are some overlaps. So they are quite similar to each other, the introduction and the conclusions, I think. And as for the relevance of the book, of course, there is no doubt that the book is highly relevant, because, as you say, there is growing diversity, of course, in manifold dimensions. And because of that, as Francesco, who is, I guess, connected also with us in this seminar, wrote in his blurb on the book that the world is multi-level. And that, of course, has much to do with growing diversity, because as you also put it in your in the book at one point, if there were no such underlying need through diversity, the systems could also be constructed in a different way. So multi-level structures follow in many cases from different different diversity markers. As you pointed out in your short introduction, Maja, I think what is really a main asset is that you focus on convergence and divergence. And the end is really important here, because that is something that was that Bruno de Vita wrote in his preface, that actually, of course, convergence was the main focus until recently, and divergence was something rather neglected. And he also points to different concepts, of course, of divergence, so constitutional transplants, migration of constitutional ideas, or also institutions of convergence like the Venice Commission. And so I really find it very balanced that you say that there is both convergence on the one hand, but there is also divergence on the other hand. And of course, your point of departure regarding those two concepts is that you say that actually there is, of course, a tension between the two. There are contradictions and they have to be accepted. So there is this nice sentence which I would like to quote. Multi-level orders are not unfinished products waiting to be finally consolidated into something more coherent. So it's a work in progress, and it has to be a work in progress. Any multi-level order has to be a work in progress. And you define neither convergence nor divergence as something that is preferable. So your answer is it actually depends. So you say that it's the normative factors that determine what is actually preferable. Are stability, democracy, rule of law, and etc. And it depends really on the context, what is really the better course to take. So this brings me to my first questions, because you say that the normative factors, so as I said before, stability, democracy, rule of law, you say etc. So are there also more normative factors? And also, of course, they sometimes conflict with each other. So taking just the example of the bond powers of the High Representative in Bosnia and Herzegovina, which is, of course, a clear example of that you know, of course, very well, Maja. So how then to deal with conflicts and contradictions between those normative factors, stability, democracy, rule and law, and how to prioritize? So this would be a first question. Then you say, what course to take depends very much on the context. And you say that also the accommodation of diversity and through legal mechanisms is very much a context-sensitive task, as you say at one point. So there, of course, this is for the lawyer speaking in me. This is, of course, a very convenient position, because you can. This is kind of a fallback position that you can say, okay, there are legal mechanisms, but in the end, it is very context dependent. So from my political science perspective, then I'm just thinking from the perspective of neo-institutionalism in political science, which says that, of course, institutions, legal mechanisms enable and constrain the choices that actors make. So there is, of course, some impact of institutions and legal mechanisms, but where are the limits of the law is really a key question, I think. And because you also at one point say accommodating diversity is a context-sensitive task, and I quote, "It requires the good faith of all agents involved and the openness of legal orders to amicably search for constructive solutions." But of course, what shall we do if there is no good faith, and if people don't want to look to be constructive, but they want to be destructive, as it is quite often the case, obviously? So this is, I guess this is a perennial question, of course, about the limits of the law. And I always think in this context about the secession reference of the Canadian Supreme Court, where the Supreme Court said that all parties to the federations, or all provinces, and also the national government, they have a constitutional obligation to negotiate in good faith. But the question is then, who assesses, who judges whether actually they act in good faith or not? And the Supreme Court itself said, well, we are not that institution. So is it a legal institution? Is it just political mechanisms that shall ensure good faith? And of course, another second scenario is also, even if all actors acted in good faith, it still can be a situation can still arise in which no agreement is made, so that diversity actually is not accommodated because the positions are just too far from each other. So those are, I guess, very, of course, very general questions, but which are very much related to some of the conclusions of your book regarding this context-sensitive task of accommodating diversity through legal mechanisms, either tending towards convergence or divergence. So, because otherwise, of course, we as lawyers, might end up with a plea for good faith, and then with wishful thinking that actually this will be the case, and we cannot do much about it, which is, of course, very frustrating, obviously. So we don't have time, of course, to go really chapter by chapter through all the many chapters that are assembled in the book. So I would like to focus on some which are also more related to my expertise, and which also were written by authors who are present, because I don't think that it would make sense to delve into chapters whose authors are not here in this book discussion. So of course, your chapter, Maja, attracted my curiosity, as we share common interests in our research. And I found it, of course, very interesting, your topic on asymmetry and dynamic stability. And you brought together Belgium, Iraq, Indonesia, and Bosnia and Herzegovina. So what I was thinking, because you explicitly limit your study to variations in status, power, and financial competences. So I was thinking, as of course, federalism is in its minimum definition seen as self-rule and shared rule, whether asymmetry you would also regard asymmetry regarding the latter dimension, shared rule, so of course more through intergovernmental relations mechanisms than through second chambers, whether you consider them important, but because they don't get the space that self-rule related asymmetry gets in your chapter. So is it because you consider them irrelevant, or what is the reason behind that? And then I was wondering, because of course Belgium, Iraq, Indonesia, and Bosnia and Herzegovina are quite different case studies, so they are quite far apart. Now coming back, of course, to the question of the context, because of course it's totally different contexts in those 4 countries. And I was thinking especially about having Belgium on the one hand, and you are of course very much familiar with Belgium, and Iraq on the other hand. So it made me think about a journal article in Ethnopolitics that our colleague Eva Maria Belzer authored, and she also, during a seminar at URAC in June, she also presented the Iraq case, where actually she said that the failure is not so much due to a failure of federalism, but it's a failure of state transformation. So it's actually not so much federalism to blame, because actually federalism is not really existent in Iraq, because you have a quasi-independent region of Kurdistan, and you have actually other parts of the country that very much depend on the national government, which have actually a very centralized regime. So the question is how that is comparable, the Iraqi case, to the Belgian case. And a third point is, again, regarding context, the power of political factors, because one of your argument is, or your main argument, I think, is that adaptiveness and trust and interaction are important within multi-level systems in order to create cohesion, and as a result of cohesion, also stability. So here I'm also wondering, again, whether this is something that we can create. Can we create trust through legal mechanisms? And especially in your case, constitutional asymmetry, because I'm always a bit skeptical about that. I remember that at our winter school, which you very much familiar with, of course, I remember once having had a conversation with one of the pioneers, let's say, of power sharing. So not the Arendt Leipart traditional power sharing, but liberal power sharing. And this quite famous scholar was very confident, in my view, overconfident, that by putting people at a table together, trust will follow. So as someone from Bosnia and Herzegovina, I think you would very much disagree with this view, and I disagreed as well. Again, there is the question of the political factors versus the legal factors. Then as for the other chapters in the book, I would like to treat them within a common theme that I noticed that also Jakob mentioned before, that the focus is very much on the EU. And you said also, Jakob, that it's not limited to the EU, but still, as someone coming, of course, from federalism studies, looking at the national and the subnational level, I found that the subnational level was a bit underrepresented in the book. So your main focus was on EU national relations. And so when I read multi-level constitutional orders, I expected the subnational level to be more present in the chapters, because I really think that actually the book could benefit from having a subnational element, more of a subnational element as well. So just regarding constitutional identity, which is also a key topic in the book, in the conclusions, you say that constitutional identity serves to legitimate divergence, which is of course again in EU national relations. That of course it's a tool to justify divergence of national orders from the EU, right? But then on the other hand, the national constitutional identity, of course, in relations to subnational constitutions, has quite the opposite function, because there it is, of course, a tool of convergence that kind of ensures the harmonization of subnational constitutions. And so relating this point about your mainly dualist focus on the EU national level to single chapters, Marjan's chapter 4, for example, on constitutional differentiation, there you say that constitutional specificities, of course, are accepted as long as they respect the common values laid down at the EU level. There, of course, it would also be interesting to what extent subnational constitutional specificities are accepted. So going one level down, and of course, you then find in national constitution homogeneity clauses that say that actually subnational constitutions can only deviate to a certain extent from the rules or values laid down in the national constitution. A second chapter, which also could have a subnational element, is Jakob, your chapter 6, which I found very interesting, because you say that a multi-level fundamental rights landscape is actually something that is normatively desirable. This multi-level fundamental rights landscape, however, does not necessarily have to be limited to the EU level and the national level, because in many federal countries, of course, you have fundamental rights at the subnational level. So as Lentar, so one of the main experts in subnational constitutionalism, pointed out regarding the United States, the US Bill of Rights actually is just a floor. It's not a ceiling. So it's a floor of fundamental rights protection that the states can build on. And is similar in several other countries as well. In Germany, for example, where you have fundamental rights in subnational constitutions. In Spain as well, you have in the, let's call them quasi-constitutions, in the statutes of autonomy, you have fundamental rights. So it would have been interesting to see in this three-level perspective, the interrelations not only between the EU and the national level, but also including the subnational level. Then the third and last chapter in which actually the subnational level could figure more prominently is regarding foreign affairs. So the EU's foreign affairs constitution. Because what came to my mind is, and Maja, probably you were already in Belgium in 2016, as far as I remember. What came to my mind is, of course, the role that subnational identities in Belgium can, of course, play in foreign affairs, and did play regarding CETA. So the agreement with Canada, where actually it was Wallonia that held up everything. That's Belgium actually, because in Belgium, it is according to the parallelism between the internal competences and the external competences. The regions and the communities have powers, external powers over everything, any subject matter that they are responsible for internally. So it came to a point then in the end, as far as I remember, that members of the delegation, of the Canadian delegation, the trade secretary, went to the Walloon Parliament in order to convince MPs in the Walloon Parliament to say yes. So this is really also something where the interrelations between not only two levels, but three levels could be very interesting regarding the EU's foreign affairs constitution. So, of course, you also acknowledged that at one point in your book that the term multi-level constitutionalism is most frequently used regarding the European Union, and especially German constitutionalists. I remember some 10, 15 years ago, already used this term, especially multi-level constitutionalism for EU national relations. But to me, of course, from a federalism perspective, this dualist approach is a bit limited. And of course, it is also something that has to do probably with your expertise, because I think most of the editors, apart from you, of course, Maja, and also most of the authors, mainly have their primary focus in EU constitutional law. So this is probably also a reason for that. So this is, of course, no fundamental criticism, but just something that, reading the title, I would have expected more subnational, that the subnational level being more present in the book. But of course, that is something that could be maybe something for a follow-up project to look at all three levels. And so I guess I will stop at this point and then wait for the Q&A session. Thank you.
Okay, so thanks a lot, Karl, for these very detailed inputs. And I think that's certainly a lot of food for thought also for our editors here. So I'm sure that the editors have some reactions to your inputs, but maybe I would propose to structure like the last 30 minutes like this, so that we have first a short round of reactions by the editors on Karl's inputs, but really like I would ask you to be really short on that, because there's already like 2 questions on the chat and maybe there's some more questions coming in, and I would also like to give the floor to the participants also for their questions. So Maja, maybe I head over like immediately to you again for a short reaction to Karl's inputs.
Yes. Okay. So just to leave enough space to the colleagues, I'm gonna reply to everything that was directed to me, and then I'll leave the first part of the questions to Marjan and Jaka and Julian if they want to pitch in, because I also want them to interfere. But because you also commented on my paper and Teresa handed in to me, I'm going to quickly reply to that, and then we can go back and forth. I think, and then I think Jakob was also in the game for the answers. Yes, you mentioned intergovernmental mechanisms. I do not underestimate them. On contrary, I think they're very important, and I think in terms of self-rule and shared rule, in order to strike the balance in some systems, I've noticed that those intergovernmental mechanisms have been used in order to symmetrize the systems as well, but also to, let's say, create more grounds, more fundamental basis for holding the system together. And so for that reason, for example, you mentioned Bosnia and Herzegovina. I do think that they contribute to coordination, and I do believe in them. And for many times I've mentioned that as a coordinative mechanism, they should be used in highly divided systems such as Bosnia and Herzegovina in order to connect levels of government if there are no other ways. Which is actually connected with the third part of your question, and that is trust. How is it even possible to create trust when there are asymmetrical relationships within the system? I think, and that is based on my research, I think most of the distrust actually comes from asymmetry, from the asymmetrical positioning within the system. I do not think that trust itself is maybe the word, or now I'm trying to explain it even in a more complex way than it already is. But I think the trust itself is not the trust of trusting somebody as we usually see it, what is good for another person. But I think the trust that I consider in asymmetrical relationships is actually the trust in expectations in the management of the system, that there will be no overpowering, and that means stabilizing those expectations on a basis of, belief that there would be no overpowering. That is in connection with withdrawing from the vexed concepts that we are used to in asymmetrical systems. Normally, in traditional federal theory, we see a push for more symmetry, for more unity, for more harmonization, etc., for more, let's say, equal status, sort of to say. I don't think that is in the essence of the concept of trust in asymmetrical systems or systems that are asymmetrical themselves. I think also there is a push for more loyalty, for more homogeneity, and that is something that we also do not want. Accepting or stabilizing the expectations actually means accepting that diversity exists, and that is actually the basis for the trust. So I think the trust itself cannot be created through asymmetry, but it's that this trust is created through asymmetry, and trust itself should be based on the acceptance of diversity. I hope I'm making any sense out of this. And then you mentioned also the relationships, the relationships in terms of using different types of non-comparable cases of Iraq, Belgium, and so on. I think when I approached the research, these are not the only cases that I've used, but normally I've used these cases because there is a minimum requirement that I want my countries, sort of to say, to fulfill if I want to deal with them. And that is normally that they have at least 2 tiers of government, that they have subnational entities, and that the central tier is mixed, with the subnational entities. And of course, they have to have the element of identity factor, that they have to have diversity factor. Indeed, I think you mentioned also that in Iraq, it is actually not the failure of federalism, but actually the non-existence of federalism, or the failure of the state transformation. And I agree, I completely agree with you. And I think that we need to look out, and I think maybe that is related to the normative factors when you said, are there more? When you say, there is this, there is that. So is there more to that? I think that as lawyers, and you mentioned it, we as lawyers, I think as lawyers, and I mentioned it in Canada a few days ago, we have a very institutional approach. And with this institutional approach, we do apply some limitations. And that is maybe also part of the answer to your question. Probably Marjan and Jaka will attend to that. With that institutional approach, we limit ourselves to the institutions, to the procedures that are part of this institutional approach. But we often forget that there are also political actors. As you said, in Bosnia and Herzegovina, it is very difficult to perceive that, you know, people would trust each other just because, you know, we said, okay, these are asymmetries here, go and work with it. So this institutional approach does have limitations, and we do have to take into consideration that there are some political aspects or the aspects related to political factors, such as the political elites or the positioning of the political parties, the way they are structured. I've often mentioned also fragmenting and integrating political parties and so on. So these are also some of the aspects that we need to take into consideration. And I do not think, and I do not believe, if I didn't believe in federalism, I don't think I would be doing this. But I think that you're right when you say that federalism itself did not fail, but actually, I think our approach and how we comprehend it actually failed. I leave it now to the rest of the crew because I already spoken too much. I hope I answered at least part of your concerns.
Thank you very much, Maja, and thank you very much, Karl, really for your comments and observations. And I feel like we should have had this discussion before we put together the book, because really none of your comments were in the direction that something is fundamentally wrong with the arguments or the conclusions we make, but only with ways in which we could make them better, stronger, more well-rounded, more widely applicable. And I really thank you a lot for that. I will touch upon two sort of smaller issues. First is the one that you mentioned at the very beginning, which is how do you manage a project with 5 editors? But that's not really the part that I'll focus on. But how having 5 editors is seen in having an introduction and conclusion, which are sort of similar. And I would say they are sort of similar, but they are also different in some very important ways. They put some different twists to the general idea that the book is trying to put forward. So in the introduction, our main aim was sort of to show why this discussion, like Maja said in the beginning, after 20 years is still important, or again important, how we can best conceptualize the contribution the book is trying to make. But the conclusion was more focused, I felt, on the overall approach to these issues that the book promotes. So that is really about, as you pointed out in the passage that you quoted, it's really about sort of embracing contradictions and paradoxes and trying to work around them and through them, rather than trying to resolve them and find sort of a coherent solution. And the conclusion really tries to show that these go hand in hand, and that all the mechanisms and the theoretical approaches that the book discusses are sort of the same when they mediate either convergence or divergence, that these are not two separate issues to be discussed, but that they are being mediated through the same theoretical approaches and through the same mechanism. So that would be just sort of first input, also in the light that Jakob didn't say very much about the introduction and conclusion, so that people in the audience can have a bit of a better idea what to expect if they end up buying the book. But the second question I would like to address is the one that you pointed out first, which is about normative factors, and how do different normative factors determine what outcomes we should follow, and how do they interact between each other. And I would say that the book is deliberately agnostic about that, because the book primarily hopes or tries to show ways in which we can think about prioritizing these different normative positions, rather than engaging in a normative discussion in and of itself. both when we talk about the theoretical frameworks and when we talk about specific sort of conceptual juridical mechanisms, however you want to call them. And the reason I say this was an intentional decision is because we wanted to make the book as globally and as widely relevant as possible. And we say this in the book as well, even though a lot of it is drawn from the EU and focuses on the EU, these are really conclusions and methodological approaches that can be used in a variety of systems that are in no way related to the EU. And that is the reason why we left this normative discussion and normative factors as to what the outcomes we are trying to achieve are to decide. And as for the other question that you mentioned, I will hand it over to Julian, which is the question of what happens if the cooperation is destructive. What are the limits of the law? And the reason I handed it over to Julian is because he also recently published a different book about abusing constitutional identity. So I think your question fits really well into his specific area of research. So Julian, over to you.
Yeah, I'm not gonna try and turn this into a separate book pitch, but just to briefly address that question. And I think you're right to point out that there is definitely a moment where we run out of law to manage diversity in these types of systems, right? And that point definitely comes when, rather than just talking about accommodating diversity and having different mechanisms that can either lead to convergence or divergence, we see diversity used as a means of conflict, right? And that would probably be a subject for another book that would probably make for a great edited collection, that rather than looking at how to accommodate diversity, what different mechanisms there are available in different multi-level constitutional orders, looking at rather conflict, right? Looking at the more say agonistic aspect of relations between different, for instance, member states and supranational organizations, or national and subnational units, and so on. And that there probably, one of the takeaways would probably that there will very quickly come a point where we run out of law, and we're left to deal with things in different ways. And that's one of the things that ultimately I end up arriving at in my own book as well, that ultimately it's not something that can be solved legally, but that just has to, that draws us back into the sphere of politics at some point. Yeah. No.
Thanks. So maybe, Marjan, do you have still some points? Or
maybe just shortly, yeah. I'll try to be as short as possible.
Thank you.
So first of all, really thanks for the interest in the book. And this discussion is really, I mean, it's really fruitful and provides a lot of thought for what could, I hope, potentially be a follow-up sometime in the future. And as you said, it's still, yeah, it's a work in progress in terms that this book, I think, was not meant to be comprehensive, either in the theoretical part or in the mechanisms part. And as you correctly point out, we were mostly focused on the EU, and we did not focus on the subnational level as much as we could or probably should. So yeah, there are, we all know very well different doctrines from federal law, from supranational law, from the EU even, that could be discussed like common constitutional traditions, or I don't know, the paramountcy doctrine in Canada, or the marginal appreciation that Professor Palermo is also mentioning in his question. So yeah, there's a lot to build on. I think that the key takeaway is the one that you pointed out as well, and that is that this is the kind of the premise of the book is that there's no ultimate solution, and that we should accept that in some systems this is a permanent state of relations. So this dynamic that exists within multi-level systems. And then moving to the questions, and I'll relate here to what Julian said. So the question was, where do we run out of law, and what are the limits of law? Of course, our position is cozy, as you said, because from a legal perspective, we can just say, okay, well, the law has no answer here, and that's, I agree with what Julian said. But I think what our aim was to try to find different mechanisms that could solve the tensions within multi-level systems within the legal framework available. And the mechanisms that we present kind of show the potential uses, and we also see that some mechanisms can be used both in the way that they lead to convergence and divergence as well, and show their applicability, which I think can be extended to other systems, not the EU, does not only apply to the EU, but can be extended to other systems as well. But here again, I think, crash against what was, I think, your critique, but I think we can all agree that it's also, it could be accepted as a mere fact that context does define the way these mechanisms function. And you mentioned Canada, for example, and the decision on the secession of Quebec, and this, I think, shows this context specificity. Because, for example, in Canada, the Supreme Court said, well, it's not up to us to decide whether you're loyal, whether you use this loyally or not. But if we moved, for example, to the EU, we would have the Court of Justice of the European Union who would say, well, the use of this mechanism violates the principle of loyal cooperation, and you cannot use it in this way. And I think this is partially also the answer to the attempts made by some of the autocratic regimes emerging in the EU. But of course, as I said, all this discussion still stays within the constitutional framework of the whole system. And then the question that you pointed out as well is, well, what if there's no solution within the system? What if there's no agreement reached? What happens then? And I think this is what Julian mentioned as well, as that at one point, we're dealing with conflicts that cannot be solved legally unless you have a clear hierarchical structure, as you do in federal systems. Because, for example, in the EU or in I don't know, any other system, international system that has Council of Europe, which is again specific, but still, you have a different dynamic, and this different dynamic will determine how far law can reach. And in the EU, for example, you don't have a legal solution. If the German Constitutional Court says, well, we're not going to respect what the Court of Justice said, we'll just do it our way, you run out of legal answers. And I think this is what the Weiss decision showed in the end as well. And it was actually a political decision that was reached and solved, or just put it under the carpet, the problem that emerged there. And yeah, and then I would just shortly deal with one of the questions in the comments as well, that was raised, and that's to what extent it could be constitutionally required to accommodate certain kinds of diversity. This again, I think, is a good example of how context-dependent answers to the issues we tackle are. Because, for example, again, the EU is as a standout example for this, and Julian and Jakob will probably both have their own take on this. But the concept of constitutional and national identity, for example, is one such concept that could be used to identify what parts of diversity should be or should always be constitutionally required to be accommodated at the central level, for example. Whereas in federal systems, again, I think the answer is different, because the extent to which subnational constitutional diversity needs to be accommodated at the federal level, I think the answer to that is mostly, and you can correct me if I'm wrong, but in my understanding, it's just the supremacy clause determines, or the Constitution determines, the federal Constitution will determine the scope of what is acceptable in subnational constitutions, and the dynamics is again different. So yeah, I'll conclude with this because I want to leave some time for further questions as well. And I hope we at least partially answered some of your very interesting questions. Thank you.
Thanks a lot. So I don't want to bypass anyone. So if Jakob, if you have some short reactions, please feel free to add them now, but please just like really quickly so that we can still address the questions in the chat. Thank you.
Yeah, thank you very much. And also a big thank you. I don't know, I cannot put the camera on. Anyway, so a big thank you to those comments, which were really thorough, and like the best thing that one can have is basically a reader which takes it seriously. So that's great. So just very shortly, like it has been mentioned that that we have contradicting normative foundations, and because we have different normative commitments that we are all committed to, but they're contradicting somehow, we have a problem because we don't know how to apply those mechanisms. And I just want to highlight that basically that's the very nature of a liberal system. We have democracy and rule of law which are contradicting, and this doesn't mean that we don't have a functioning system to a certain extent. So basically, to put it in different words, what my colleagues really explained well already right now, I just want to say we didn't want to give you an answers. We wanted to get to know those mechanisms. So not to decide how to decide, but more to be acquainted how those mechanisms can work in particular circumstances. And now just shortly coming to a point of identity, and I will just use this example to highlight this answer. So in a way, what I was trying to do in my chapter is to show that perhaps an identity is not a productive tool in a certain context. So in a way, if we have the multi-level fundamental rights protection, we should perhaps go away from identity claims and to use better ways how to accommodate those differences. So in a way, yeah, that's just from my side. Okay, I will leave it here. Thank you.
Thanks a lot for this. So there's still some time to address the questions in the chat. I'm going to read them out loud so that everyone also has them present. One is by Francesco Palermo, who writes, margin of appreciation has been mentioned as one of the tools to protect or consider national constitutional identity. This doctrine has certainly been elaborated with that purpose. Do you believe it is still the case, or has the constant resort to the margin of appreciation by the European Court of Human Rights turned it upside down and made it an instrument of divergence, a tool for asserting claimed national identity to the detriment of a European integrated identity? And I'm going to read out the second question as well so that everyone has it also. Marjan already addressed parts of it. The second question is by Boyar Tao. I'm really sorry if I mispronounced the name. Who thanks for the opportunity to attend the book presentation and sends greetings from Tirana. And he asks, he says that you rightly say that what course to take in accommodating diversity depends on the context diversity marker at hand. Do you have a proposal about what is perhaps a minimum standard or some kind of constitutional imperative as to what extent it is constitutionally required as opposed to simply allowed to accommodate certain kinds of diversity, for example, language diversity or ethnic racial diversity? So I would propose that maybe one or two reply to it in order to, because I think we don't have time for another round by everyone. So I don't want to call on anyone depending on expertise, just raise your voice.
Until we figure out who's the expert on the margin of appreciation, I'm going to answer the second question if that's okay. But I think Jaka or maybe Julian could definitely do that. But I think Marjan actually addressed the second question to some extent. But I think, not insisting, Karl actually identified, and maybe that's the issue here in terms of why I might oppose now what Marjan says about having the federal clause and so on. I'm pretty much the only one who's interested in the subnational aspects of all of the issues that we discussed here. And I chose not to push forward too hard in the favor of discussing more of these concepts, because I was also very much saturated and I wanted to learn more about something different. So I did not push for that. But I think, Karl, you identified it perfectly, that aspect is kind of left a little bit aside. And therefore, I think the question that we see here, I understand what Marjan said. For the European Union level, I definitely agree. But then for the subnational level, I think this would definitely depend. Here it's mentioned language diversity, ethnic diversity. I wouldn't say necessarily racial, because that's a biological factor and so on. But it really depends on the type of diversity, and it really depends on how strong the push for autonomy from the bottom up actually is. And we've seen it in Spain with the independence referendum, and Karl, you also mentioned the secession claims and so on. So it really depends on how strong the push from bottom up actually is. None of the systems is actually the same. I did a comparative research on different systems based on subnational approach, and there is no composite answer. We only have very generalized opinions about it. But and as I said, in order to approach some of the research, for example, Iraq and Belgium may not seem systems that could be compared, but on a very general level, it is possible. So, so from that perspective, I think we need to think about every system specifically. We need to think about the context of that particular system. So I do not think that we have a general proposal, because that is very a specific thing that is actually pertinent to a specific system. And I'm sorry that I cannot be more logical, but if we did have an answer to your question, I think we wouldn't have problems with the countries like Bosnia and Herzegovina that we mentioned today on a few occasions.
And I can take over the margin of appreciation question, which I'm very to avoid or not to avoid the pun, very appreciative of, because it allows us to say a bit more, not only about the margin, but also about sort of the general approach we had to the book. And what I mean by that, someone reading this book might be very surprised that there's no chapter on the margin of appreciation in a volume like this, because it's such an important concept which would fit really well with the book. At the same time, someone might ask, especially in the part on the theoretical perspectives, well, why did you decide to discuss these theoretical perspectives and not some other ones which are also pertinent in these contexts? For instance, I don't know, constitutional pluralism, its many varieties, etc. And the reasoning or the thought behind it was that we would try not to include chapters on topics which are already well discussed and well rehearsed, where there is plenty of literature already, but we will try to bring something new to the discussion. And that is sort of also the decision, where the decision not to have a specific chapter on the margin of appreciation comes from. I guess I would be the one who would write the chapter given the contents of the chapters we have currently, because consensus analysis or the European consensus doctrine is also one of the determinants of the margin of appreciation. And I thought that focusing on consensus rather than on the margin of appreciation would also be better in light of the goal that I mentioned before, which is to make the book as broadly attractive, as broadly relevant as possible, because obviously margin of appreciation is a very ECHR-centric concept, whereas consensus, as I show in my chapter, is used by a variety of courts in very different ways. And the idea of using consensus to decide cases is widely applicable and is widely used. As for the specific question on the margin of appreciation, I think we could say, or we could arrive at a conclusion in a very similar way than we did with most of the mechanisms that we discussed in the book. It can be either one or the other. It's not a mechanism of convergence and it's not a mechanism of divergence. It's a mechanism through which both can be achieved, and it's a mechanism of mediating diversity, of accommodating diversity. And we can see this if we look at different cases and how the margin has been used in different cases. For instance, one of the cases which have been talked about a lot and which is very exemplary of what the question refers to is the ABC versus Ireland case, right? Where the national identity of Ireland was so strong, and again, we come back to consensus, was ranked so strongly in a sort of normative sense that it overruled a complete consensus against the types of the type of regulating abortion or abortion regulation that we knew in Ireland at the time. And so the value of national identity was so strong that it overruled almost a unanimous consensus against it. So we can definitely see that in the case law of the ECHR regarding margin of appreciation and how it can be used in these processes. Thank you.
Thanks a lot for these reactions to the two questions. We are drawing to a close in terms of our time left within the webinar, but just also facing the danger of maybe going 5 minutes over time, I would like to just do a very short round of wrapping things up. But before we're going to do that, because I know how it works with webinars, once we draw to a close, that everyone is slowly fading out. So I would just like to put a very short advert regarding our winter school on federalism and governance, also because it has been mentioned before, and it has been one of these occasions where we also met Maja, and it was the start of a very productive and long-term collaboration now. So the applications for our yearly winter school are currently open. The winter school is usually taking place in the first 2 weeks of February this year, in the following year, 2024, from the 5th to the 16th February. And the topic of the winter school this year, next year is going to be about federalism and sustainability, analyzing the relation between multi-level systems and the concept of sustainability. I'm just putting the link to our winter school in the chat so that people who might be interested in it can look at it and maybe also share it with contacts or students, because it is really a good occasion to exchange with researchers and also to start more long-term collaboration and networks. Now, for our concluding round, I thought we could really do a really short round of 1 sentence each, because some of the aspects which also Karl mentioned and I really liked about this book was also this perspective of young scholars. And you put it also in the book that it will be the voices of these junior scholars that will importantly shape how multi-level legal issues will be able to address current and future issues of accommodating diversity in multi-level systems. So to close off, I would ask the editors to each just briefly state what in their eyes is the main takeaway from the book. So one main lesson to ensure that multi-level legal systems will be able to accommodate diversity both today and in the future. So just really one round, and you can of course also add some greetings. And I think, yeah, let's start with Maja again and then just do the round. Thanks.
I think I will be I will approach this as a layman, because when we were discussing the actual book proposal, we returned to a lot of "it depends." And I remember we said "it depends" so many times that it really stuck with us. So I think the answer to all of the questions, are there more normative factors? It really depends. How to deal and prioritize? It really depends. So I think the answer that this book is actually giving us is that every single question that we ask is actually that it depends. So yeah.
Thanks, Maja. Over to Julian. Julian, can you?
Oh,
Sorry.
I don't have much to add.
Okay. So in case if among Jaka, Marjan, or Jakob, someone has to add something.
Can you? Yeah, I think I'm unmuted. Yes. Yeah, perfect. Just to add to what Maja said, the book does say that it depends, or that is its message, but its message is also that we should embrace this answer and not to try to come up with coherent universalizing solutions to these questions, but really to embrace the relativity, the complexity, the paradoxical nature of the relationship between multi-level orders.
Thanks a lot. So I see Marjan unmuting himself. Sorry.
No, sorry. I just wanted to say what Jaka said. I think this is the main message. So there are different ways of how to accommodate diversity, and the message is we should strive to do that. So kind of be open to different solutions, which are, as we said, context dependent. So I would just like to say thank you again for having us. It was a really nice discussion and a very valuable one, and I hope we get to meet in person as well. Thanks again.
Okay, so thanks a lot also like from our side to everyone who joined, to all the to the presenters, to the speakers, and our discussant, and also to the technical assistants once more. And have a nice evening, everyone. Thank you for joining.
You too. Thank you.
Thank you.